Thank you, Senator. Today, and good morning. Because of time constraints, we'll start promptly on time. It's now 9 o'clock. Good morning. Today is July 29th, 2015. It is, by my clock and watch, around 9:01 a.m. My name is Tom Nadeau. I am the Chief Environmental Public Health Officer with the Division of Environmental Health of the Department of Public Health and Social Services. We welcome you all to this public hearing, where we will be accepting and hearing testimonies on the proposed rules and regulations governing Joaquin Casey Concepcion II Compassionate Cannabis Use Act of 2013. And with me today is Ms. Rosanna Rabago, Environmental Public Health Officer, Administrator, as well as Ms. Michelle Lastimosa, Environmental Public Health Officer 3, and Ms. Cynthia Naval, Planner 4 with the Division of Environmental Health. Also like to recognize our Director, Mr. James W. Gillen. And also I'd like to recognize the Honorable Senator Tina Munoz-Barnes. We thank her for coordinating the use of this facility. Thank you, Senator. The promulgation of rules and regulations is governed by the Administrative Adjudication Law, otherwise known as the AAL. And the said law requires that 10 days prior to the public hearing, a notice must appear in the newspaper of general circulation in Guam announcing the date, time, and place of the public hearing. The department did comply with that provision by publishing the announcement in the Marion's Variety on July 15, 2015. And although it was not required, the department published a second announcement on July 28th, which is yesterday. In addition, the notice and the proposed regulations were posted in the department's website, official website at www.dphss.guam.gov. In fact, the regulations can be downloaded and viewed by the public. As part of the AA procedure, it was determined by the department that these proposed regulations are exempted from the requirements of the economic impact statement because the annual economic impact to the general public, and I emphasize that, will be less than $500,000. The Joaquin Casey Concepcion II Compassionate Use Act of 2013, hereafter referred as the Act, was passed by a voter initiative during the general election of November 4, 2014. Then on February 16, 2016, Acting Governor Raymond S. Tenorio assigned and designated the initiative as Public Law 32-237. The Act mandated the Department of Public Health and Social Services to promulgate rules in accordance with the AAL procedure for its implementation. In conformance with the Act, the Department drafted these proposed rules and regulations to adjust the following, which I shall list. Govern the manner that applications for registry identification cards and the renewal of ID cards for qualified patients and designated caregivers be considered. Define the amount of cannabis that is necessary to constitute an adequate supply, including amounts of topical treatments. 3. Identify criteria and procedures for including additional medical conditions, medical treatments, or diseases to existing list of debilitating medical conditions. Identify requirements and associated fees for the licensure of producers and cannabis production facilities and the procedures to obtain licenses. Develop a distribution system for medical cannabis. Determine additional duties and responsibilities of the advisory board. And set application fees for registry identification cards so to defray the administrative costs of implementing the Act. 4 stakeholder meetings were held to address any concerns by affected government of Guam agencies, healthcare entities, law enforcement agencies, the banking, financial, and health insurance organizations during May and June of this year. The minutes of these stakeholder meetings will be made available to the Guam legislature as part of the AAL process. But for the purposes of this Act, for the purposes of this Act and these proposed rules and regulations, Department intends to treat marijuana for its stated purpose, which is a compassionate medication to treat those with identified debilitating medical conditions. The Act clearly defined the Department's roles and responsibilities in implementing the Act. It is important to note that there are several issues relating to medical marijuana that are not addressed in these proposed rules and regulations because they're simply outside the scope or the authority of the Department of Public Health and Social Services. We have scheduled 3 public hearings to receive the input and comments of the public on the proposed regulations. Upon the conclusion of these hearings, the Department will review all received testimonies and make changes to the proposal if necessary before it's transmitted to the Office of the Attorney General for their legal review as required in the Administrative Adjudication Law. After the Department receives the review and approval of the Attorney General, the finalized draft will be provided to the Governor for his review and onward transmittal to the 33rd Guam Legislature for hopeful adoption. Given the time constraint of 2 hours for today's hearing, we ask for the cooperation and understanding of those in attendance who will be providing oral testimonies. We ask that comments be specific to the draft proposal. At this time, I'm not really certain how many will be giving oral testimonies. I would have to look at the list. But depending on the numbers, we may ask, as a courtesy to others, to limit your testimony to 10 minutes, if not less, if possible. But it's our intent to give everyone the opportunity to voice their comments about the proposed regulations. But please do give consideration to others in the event there are several who wish to give the testimony. But in the event that they are not able to do so today, we do have public hearing tomorrow, scheduled for the same time, same location, and there's also another one Friday, but it'll be at the Castle Mall, located in Manilao, at the Division of Senior Citizens Conference Room. And that is from 3 to 6. Thank you. And of course, you're more than welcome to submit written testimonies. In fact, you may do so within 10 days after the last public hearing, which is this Friday. So starting from Friday and count 10 days, you have that many days to submit a written testimony if you like. So with that, we will now formally accept any written or testimonies on the proposed rules and regulations governing Joaquin Casey Concepcion II Compassionate Cannabis Use Act of 2013. Sure.
Hi, good morning. Just a few housekeeping concerns. If you have any cell phones or pagers, can you please set them to silent mode? Restroom facilities are located right outside the door to the right. And please be advised that this public hearing session is recorded. Thank you.
The list first?
Yes.
What we'd like to do is call upon, we go by the order that was signed in, and we only have 2 testimonies?
No, there might be actually
Okay.
more, so you can
Okay,
just
so we'll
call
first
them.
start out by calling the first 2 on our list, and that is Mr. Andrew Andrus and Mr. Ernie Wostick. You can have the 2 gentlemen come up and provide your oral testimonies, or read your written testimonies, that'll be fine. Okay. And I do request that that you introduce yourself, and if possible, provide, if you're representing an organization, association, or if individual, that'd be fine as well, for the record. Mr. Wostick, more than with the mic, it'll be great. Thank you, sir. Just turn on the mic, sir. Is that on, sir? The red light? Thank you, sir.
Red lights.
Excellent.
Good morning, and thank you for the opportunity to visit with you today and express some views regarding the draft rules governing medical marijuana on our island. I'm Andy Andrus, Executive Director of the Employers Council, a nonprofit association of private employers that's been around since about 1966. The purpose of the council is to help develop great employers on our island, including assisting them with the overwhelming body of laws, rules, and regulations regarding the management of a workforce. And the subject of today's hearing certainly warrants inclusion in that task, and otherwise deserves the attention of all employers striving to maintain a safe, healthy work environment. The flaunting of marijuana, cannabis, is sweeping many jurisdictions throughout the country, and unfortunately, even our own. It presents challenges that confront a great majority of employers. Accordingly, the Employers Council opposes the legalization of marijuana for medicinal and/or recreational uses. And regardless of campaigns in our government and popular trends in various state governments, and whether or not even the U.S. Justice Department chooses to turn a blind eye regarding the drug, marijuana is still classified by the federal government as a Schedule I controlled substance, not medicine. It is illegal under the Federal Controlled Substances Act, And given the scourge of drug abuse on our island, legalization of the drug in any form will likely add to that menace. There is little faith that the would-be controls will suffice any more than current laws and regulations adequately control widespread drug abuse. A multitude of laws, regulations, court cases, and just good business practices have assigned the responsibility of promoting, organizing, and otherwise maintaining safe, healthy work environments to employers. Indeed, the main publicized motivation of employers in this and similar issues is and should be safe, healthy environments for employees and the public in general. Accordingly, employers should have policies, drug testing programs, and zero tolerance in order to comply with such standards, compounded by customer and government contracting requirements, including those of the Federal Drug-Free Workplace Act and regulations of the Department of Transportation. Workplace safety, productivity, health, and liability issues are paramount in maintaining great places to work. Having a coherent and attentive workforce is critical in managing such efforts. Accidents and mishaps involving employees under the influence can be devastating for an employer. Accordingly, the following points should be taken into consideration. In the 26 jurisdictions or thereabouts where medical marijuana is legal, including the 4 states and D.C. where recreational marijuana is also legal, employers may test their employees for drugs and insist on a drug-free workplace. In other words, a zero-tolerance drug policy, even for state legal marijuana, remains very much alive. But admittedly, as state marijuana laws continue to evolve, adverse employment actions for marijuana use is becoming confusing, especially for employers without clear workplace drug policies, and especially when marijuana use takes place outside working hours and has no readily discernible impact on behavior at work, particularly in situations where job performance is not monitored. Note that even prior to all-out legalization of the drug in Washington state, that state's Supreme Court ruled that Washington's Medical Use of Marijuana Act does not protect medical marijuana users from adverse hiring or disciplinary decisions based on an employer's drug test policy, regardless of whether the marijuana use took place outside of working hours. Oregon and California state courts also recently upheld an employer's right to deny employment to cannabis users and to discipline or terminate employees for marijuana use, even if the employee is legally using medical marijuana under state law. And in the majority of other marijuana states, not only may employers test for marijuana on the job, they may also test for marijuana use that could have occurred weeks before the test date, regardless of any potential adverse impact on job performance. And on June 15, 2015, the Supreme Court of Colorado, a state that has legalized marijuana for recreational as well as medicinal use, ruled that the state's lawful off-duty conduct statute does not prohibit employers from discharging employees who choose to use marijuana for medical purposes off-duty and away from their employers' places of business, even when there is no evidence that such affected job performance or that an employee was otherwise impaired while at work. The court held that marijuana remains unlawful under federal law, and as a result, an employee cannot rely on the lawful off-duty conduct statute as a basis for consumption in violation of an employer's zero-tolerance drug policy. The case was Coates versus Dish Network, LLC, and involved a quadriplegic man whose doctor recommended he use marijuana to supplement treatments. In keeping with his drug policy, his employer terminated his employment after he tested positive for the drug. current bottom line for employees is that even residual amounts of marijuana in an employee's system can be grounds for adverse action in employment if the employer takes a hardline stance with its drug policy. And here's a critical reminder. While proponents of medical marijuana may try to use the Americans with Disabilities Act, the ADA, as a route to blessing the drug, employers are only required to enter into interactive dialogue regarding a reasonable accommodation of a disability, not the use of an illegal drug. Permission to use an illegal drug is not a reasonable accommodation and could be readily judged to be an undue hardship on the employer. Case in point, in 2012, the Ninth Circuit Court of Appeals decided a case involving a group of disabled individuals who challenged actions by the city of Costa Mesa, California, to bar medical marijuana dispensing facilities. The plaintiffs claimed that they were being deprived of public accommodation for medication essential to relief of pain. Here's what the court said, quote, "We recognize that the plaintiffs are gravely ill and that the request for ADA relief implicates not only their right to live comfortably, but also their basic human dignity. We also acknowledge that California has embraced marijuana as an effective treatment for individuals like the plaintiffs who face debilitating pain. Congress has made clear, however, that the ADA defines illegal drug use by reference to federal rather than state law, and federal law does not authorize the plaintiff's medical marijuana use. We therefore necessarily conclude that the plaintiff's medical marijuana use is not protected by the ADA. The case was James versus the City of Costa Mesa." Again, given the trend that's sweeping many jurisdictions across the country and the apparent enthusiasm of our local government, more or less, to be included in the trend, employers will have to take it on themselves to protect their organization and preclude the drug and its use in their workforce. Again, accidents and other mishaps involving employees under the influence can be devastating, resulting in injuries, loss of contracts, customers, and possibly multi-million-dollar lawsuits. And even the proposed regulations which bring us here today proclaim a warning. Quote, "Marijuana use can be addictive and can impair an individual's ability to drive a motor vehicle or operate heavy machinery. Marijuana smoke contains carcinogens, those things that cause cancer, and can lead to increased risk of cancer, tachycardia, love that term, hypertension, heart attack, and lung infection. Indeed, but the hazards of impaired abilities are not limited to operating motor vehicles and heavy machinery, as the drug may impair judgment and other abilities, prompting calamities." And lastly, we can't let this one go by. The last statement in the warning included in the proposed regulation states, in all caps, "Keep out of the reach of children." Although, ironically, the legislation that prompted the proposed legislation of the drug was named for a child. Be that as it may. So, in conclusion, we advise employers to protect their assets, which certainly include employees, customers, and the public. Establish and maintain drug-free workplaces, and just say no to marijuana. Again, thank you for the opportunity to visit with you today and to express our views. Upset.
Thank you, Mr. Andrews, for your testimony. All submitted testimony, written and oral, will be compiled and transmitted through the AO process. Thank you, sir. And so with that, we'll have next presenter, Mr. Ernie Wistig.
Good morning. For the record, my name is Ernest Sablan Wostic. Thank you very much for allowing this testimony from the public, and I would like to thank Senator Tina Barnes and the rest of the members here. I haven't even read these rules and regulations, but I'm going to try to cut it shorter than 10 minutes so I can be allowed to talk later. The main purpose of me being here this morning is that, I've been hearing a lot of talks out there about people going to be making money here, money there, and everything. And everybody's forgetting that this is about the patients. This medicinal marijuana is for the people that really in need. Forget about, everybody's talking about hundreds of thousands of dollars can be made. Even when we first start talking about the marijuana here, it was brought up by Mr. Gillian. Now just imagine how many thousands of dollars. God, this is not about money. This is about our patients. This is about the people that really needs it. So the first thing I would like to say is to allow each patient that can cultivate. They should allow those patients to grow their own medicinal marijuana, because it's about them. It's not about us making money. God, I love to farm that because there's a lot of money, but deep inside, it is not right. It is only right because the law, it says compassionate, conception compassionate, and I keep thinking about that. So we should allow individuals that are sick that can grow their own. It was even mentioned that it's $500 an ounce. If I was sick and I need $500 to go buy my first medication, I'd probably die. I'd probably die of stroke without even taking marijuana. So forget about the $500 an ounce and $300 an ounce. Let's think about our patients. Patient first, before dollars. Don't even charge the patient to get a permit. They should just go to the doctor, get a prescription, allow this patient to grow so many ounces, what they need. Let them grow so many plants. And when they finish that, they can grow again, and to make sure that they have enough for that patient. And like I said, I'm going to be reading this, and then I will be giving more testimony. So this morning, that's all I wanted to say is, let's think about the patient, forget about the money making. Allow the patient to grow it. Don't charge them to grow it. Let them grow it for their own use. Thank you.
Thank you, Mr. Wistick. So what I'd like to do is call upon next presenter to provide his or her oral testimony, and that is Mr. Walter, and I apologize if I mangled the last name, Sternagel. Yeah. Thank you, sir. Once again, for the record, you can...
My name is Walter Sternagel. I was just going over this a little bit, and I just got back from the West Coast. I'm sorry, Mr. Gillen. I was in Arizona. If you say we're following their code, it's really messed up. I was able to find dispensaries that are not connected to public health, which I'm happy if that's the way we're going to do it on Guam, but then it's wrong. Mr. Wistick, I agree with him by letting us grow our weed and stuff, or whatever you want to call it, medicinal marijuana, and it's patient. But then that's the way to give it to the kids, like the other guy was just, I don't think it's right. We don't have enough enforcement officers to prevent it from, you can't be there 24 hours and your nephew stop by to visit. He's a 7th grader, I'll clip a butt off. I think it got to be more restricted also, but wow, the guidelines here, over-restricted, I think. I think whoever, like, I'm planning to be one of the growers, I think in a greenhouse, fenced up and stuff, would be enough already. I don't think I have to have a warehouse and all this stuff, I agree with the fee, $35,000 for a grower, but is that guaranteeing me I'm going to spend so much for the greenhouse and everything? I'll be growing next year or what? You know what I mean?
I'd like to state that these rules and regulations are proposed rules and regulations, so they're open for revision.
That's why I'm asking.
And yes, depending on all the testimonies received and were transmitted to the legislature for the final adoption procedure, if you will, there is a possibility that changes will be made, including fees. But that's still yet to be determined at this time. But right now, that's why we're having a public hearing, sir, to accept your testimony, to hear your comments and your input to the.
Everything in here is supposedly in-house, right? I mean, from my understanding, it has to be grown indoor. Okay. Most of the weed that's selling through Arizona is growing in Northern California, man. Under companies that say they're under greenhouse, but most of it that I just got back are outdoor, grown up in Northern California, sent to companies, man. So that's why I thought when you guys said you were going to California, you found out, wow, they are growing it outdoor in California. Let's go down and see where it is.
No.
But like I said, I just got back. I'll show you my tickets and everything, pictures of the dispensaries, if you want, the pictures of everything. And they're growing outdoor, 95%, man.
From our visit, we visited with the health department at Arizona, the Arizona State Department
I visited
of Health
a couple who were under Arizona, and they were well.
And it was through our meeting with the health officials there that at no point could Arizona receive any imported marijuana. Everything that originates within Arizona's dispensaries or cultivation sites had to be grown within Arizona. And the same thing would apply to Guam. Because it's still a federal violation, which we're not discounting, it still remains a Schedule 1 violation. This law provided a means to remove that only if it's being used for medical marijuana. So again, it was our understanding that all the marijuana grown in Arizona originated from Arizona.
I'm sorry,
But sir, I think this brings a good point. That is correct. These rules and regulations, we did use the state of Arizona as a template. However, it was crafted based on the existing statute that authorized to do so, and also within the confines and interest of the island. So, granted, we did use state of Arizona as a template, but it's not taken exactly verbatim from their existing regulations at all.
I was just hoping that you somehow, I don't know if you want to say bend the rules or rewrite the thing for us farmers that, we can't afford to build a $500,000 warehouse and all that stuff, but we can do it properly by bringing in greenhouses and stuff that don't have, we'll have it fenced up like you guys want with security or whatever, but having to spend so much. So I guess we just want the rich to get richer and us to, who's trying to, I'm just trying to break even, man, with what I hate to say, but what my calling was here for was to plant that. I've been doing, I can say I'm one of the best if you want to ask. So I think I have a say in that. Huh? Okay.
Thank you, sir.
Thank you very much for giving me an
No, thank you, sir.
opportunity. Thank you very much, Senator, for helping us all the way. There's
Okay, thank you very much. Now we can have the next individual. August Fest, is that correct?
I'm sorry, I really wanted to remain anonymous, but I guess that's not going to happen.
Oh, sir,
I
if you
don't
like,
know what you
if you like, sir, you don't have to provide oral testimony. You could just submit your written testimony. And
I got some Q&A. Are we doing that now or later?
well, first of all, this is an opportunity for you, sir, to provide your written or oral testimony. It's not for us to tell you, well, unless you request information about it, but that information is available to you in the regulations. This is simply an opportunity for you and everyone else to provide their comments. We're not here to necessarily question your testimony, maybe
Right.
just for clarification, but this is your opportunity as a public part of the public to tell us your comments about the proposal.
Okay,
That is yours.
I got that, but I also have questions too, because I talked to Michelle, Department of Environmental Health, about a month ago before you guys drafted these rules. Michelle, that you? I addressed the question of home cultivation, and what did you tell me?
I did tell you
What did you tell me?
that it wasn't allowed.
Okay, and I asked you to point out where in the law that we voted on it states that. I never got.
I did make the correction that it was not in the law,
Okay,
it was
you
part
didn't
of-
tell me that.
that it was part of the
Rules.
testimony,
Testimony.
the written testimony that was given by Senator Munya Barnes as part of the initiative in favor of the
Okay,
statute.
It wasn't any part of the law.
It was not.
As far as my reading goes in the rules that we have so far, it is not prohibited, correct?
That's correct.
Thank you. That's the biggest reason I came down here for, because to get clarification on that. Because, and here's my testimony. Okay, I read that a cultivator and or a dispensary has to come up with $35,000 if he wants to sell, and if he wants to grow, so that's $70,000.
That's correct.
Double whammy.
Again,
Okay.
it's-
Why can't we, hear me out, why can't we have it the same price as any other pharmacy on the island or in the United States in general? You look up any state, a regular pharmacy, it's never over $800, $900 to operate a pharmacy. Why do we need $35,000 to open up a pharmacy of one product? What you're going to do with this, and I read all the different rules and all the different stipulations you have here, a lot of them that don't even exist on this island or in America, period. You're setting this up to fail from the beginning. You're only allowing 3 dispensaries. Now, with all these rules and stipulations, and you have to weigh every gram and everything else, somebody makes a mistake, we got to shut you down. Then guess what? There goes the price, there goes the supply, and there goes the access to the patients, if they rely on a dispensary. Me, myself, I don't plan to. You might want to think about that. And in no pharmacy does there have to be a medical doctor to be affiliated with any pharmacy. You're making rules up that I don't want to say discriminating, but that's the best word I can come up with. You're segregating us. Number one, we shouldn't have to have an identification card because we use a certain type of medication. That shouldn't be illegal in the first place. That's kind of what they did with the Jews in World War II. You had to wear a little badge that said, hey, I'm a Jew. You shouldn't have to, that's between me and the doctor and nobody else. If the cops have any questions, let them call the doctor. If there's a problem, subpoena me, I'll show up in court. What you guys got going here with this $35,000, $150 per patient, $1,000 for this person, $500 for that person, looks like government abuse, racketeering, and extortion is what it looks like. More corruption of government. That's all I can think of for right now. I know I got other things, but that's the biggest thing I can think of right now. You know, with all these rules, who's going to have $70,000? And by the way, pharmacies, they don't have to have a license and a registration. It's all the same thing. You're charging twice for the same thing. Who came up with this greed policy here?
Okay. The proposed rules and regulations, and I'll emphasize this once again. First of all, these are proposed. It's open for revision. Once again, this is the opportunity for you, as well as everyone else in the audience, to provide their testimony and give their comments, which we'll definitely take all into consideration. The price that was developed was based on several factors. One is how to sustain the program to ensure that it can't outbreak. The reality, sir, is any program, whether it be this program or any other program, at least in the department, I'm sure in every agency, there has to be a funding source to make it all possible. And I think you'll agree, sir, regardless of your position and all this, that there has to be some form of law, regulation, some kind of control in how this is to be implemented.
I agree there,
And
but a driver's license...
currently, it is still called a medicinal marijuana, not a recreational marijuana act. So we are treating it as such, and like any other medicinal product, there are governing rules and regulations, there are controls in place, and this is no different, sir.
Oh, it is. $900 versus $35,000?
Price
That's
is-
a big difference.
Price, as I mentioned, is open to changes, but our
What's that going to do to the price? Did anybody ever think of that?
Our decision to include the current price is, of course, open for changes, but is once again, it's based on the ability for the government, whether it be this division or any other program or other agency,
Government
to
extortion.
able to run. Well, that's open to interpretation. That is your interpretation, sir. But we have to make this program run. And once again, we do respect everyone's comments, but we request that you stick to.
How
to the
many
thing.
people besides the 11 on the board are you going to have to hire to implement this program?
In our preliminary assessment, there needs to have a personnel, dedicated personnel to run this program. It is our plan, as proposed, to run the program through a web-based program. And I can, of course, let my planner get the detail, but in generally speaking, we are trying to make this as efficient, as fast as possible. In other words, you don't necessarily have to come and see us personally to get your certificate, but rather everything's done primarily through the web, the internet, if you will. And that, of course, will require the necessary infrastructure, and that will cost, sir. And that's where some of the money to make that happen will come from.
No, I mean physical
fees.
people.
That will depend, once again, the volume of the number of individuals who will be seeking the certificate, the cost for the IT infrastructure. That has yet all to be finalized, if you will. It's still being reviewed.
Guam's already set up.
You cannot, please understand, patient confidentiality is one of the priority of the department and for all healthcare agencies, and this will be no different. All individuals under the program, their confidentiality will be, of course, looked into, and that requires possibly a separate system. That's something we need to, of course, still need to be discussed. We are in communication with our IT
Just an
folks.
encryption app, so it's necessary.
Well, you make it that simple, sir, but we found out it's not that quite so simple. And like, as I mentioned, sir, we are trying to make this as efficient as possible, and there are costs involved in all this.
Right.
And once again,
Right.
we
A
are
driver's
open to
license-
change the
a driver's
cost
license
necessary.
only costs $25.
I think this is a little bit different, but I understand what you're saying, sir.
They have much bigger staff that you're going to be having to take care of how many thousands of people
Sure.
for driver's license,
understand.
and you're only going to be dealing with probably at the most 10 to 12,000 people at the most.
So basically, your testimony is that you have concerns about the cost. Was that correct, sir?
Yeah, the way with the facts and the figures, and a lot of the rules for the dispensaries and the growers.
Okay.
10-foot wall, 1-inch steel thick door, whether it's inside or outside. Who's going to be, after you pay $70,000, who's going to be able to come up with all those cameras and security and, whether if you're doing it outside, which, would be best, but due to weather and everything else, it's kind of risky. a 10-foot high wall, so you can't see the plant. It's just a plant. Get over it.
Well, sir, this is where you could submit your testimony, and we'll definitely look at all comments received, including yours, sir.
All right, I will have more as we go along here.
Thank you. You have anyone on this? Okay. I'm told that we've gone through everyone on the list who's shown interest in providing their oral testimony. However, we do still have just over an hour, so we're more than happy to entertain any other, even those who come up earlier, if they would like to expand their comments and what they've mentioned. We do have just about an hour till the end of the public hearing. Please, if you'd like, come up. Oh, Mr. Wistig, I'm sorry. Just as a courtesy to those who have yet to come up, there is an individual who's seeking to provide her testimony. So once again, if I can, for the record, can I have you state your name and the organization, or if you represent?
My name is Andrea Pelicani, and I'm from the organization Guam Grassroots. Our testimony won't be ready till tomorrow, as we're still making amendments with our associates stateside to provide the proper case study. But I did have a question on the licensing options that I need to clarify before I provide case study for it. There's no option for vertical licensing. There's language in there that states that if more than one application, if I provide more than one application, I can't do it in the same village. Am I understanding that properly?
Is that for the
You have everything lumped together. There's no separate distinction in the regulations for dispensaries or cultivators or processors or labs. You lump everything together so that everybody's following the same rules, but really they're separate facilities which should have separate guidelines. And so my question is, if you want to apply, let's say I want to grow and I'd like to dispense, right? But I can't provide two applications in the same village, meaning I have to set up two different facilities, doubling my costs. I can't set up a warehouse and dispense in front of my warehouse because I can't provide an application in the same village. There's language. I mean, you guys wrote the language, right? I'd like to clarify if I'm understanding that properly.
So the way that it's written, it's the director who will determine whether or not the application submitted warrants an allocation for that CHA, or that community health assessment area.
Correct.
So with that application, he is going to make that determination whether or not there's a need for that additional dispensary or that cultivation site, and how many patients it'll serve. So if you're submitting, let's say, a dispensary application in the village of Mariso, and there's only 2 patients, he may not see a need to provide an allocation for that area. So he may give you a denial just based on it not meeting, public need for that area.
But the language says and or. So if I'd like to grow and dispense, one of my applications will be rejected because I am the same applicant in one village. The language is there. I just would like for somebody to clarify it. That's not, I understand the need base, depending on how many patients qualify in that particular area. I understand that. But there is language there, qualifying applications. If one company wants to apply for multiple licenses, one application gets rejected if it's in the same village. The language is there. I just want to know if that's what I'm understanding correctly.
Well,
I read in one section, I think I might be able to answer the question quicker than you. I read one of the sections, if you are applying for a dispensary, and then it says only for B, and you want to be a cultivator also, it's the same application, it's the same B. That's what I read. Is that correct?
that's correct. That if you wanted to be a dispensary and the cultivation site, again, it'll be based on who submits. If there's an allocation for that CHA, then it'll be the first person who submits a complete application. Now, if there's multiple applications that are complete and submitted at the same time and determined to be complete at the same time, then that's when there'll be a lottery for that CHA.
Okay, so to clarify then, because the language is very confusing about that, I can apply for a vertical license. There is nothing in there right now that states that I can apply for a vertical license with one fee.
That's correct. Every license, whether they're going to be a dispensary or a cultivation site, we will be treated separately.
Correct.
So if a dispensary wanted to grow, then they would have to apply for a cultivation site registration certificate.
Correct. But if I submit two applications to operate in the same facility, one of my applications may be rejected, correct? So if I were to apply to become a dispensary and I wanted to quality control my cultivation and quality control what I'm growing and not necessarily be at the mercy of any cultivator that I may not trust or prefer what they're growing, and I get denied a cultivation license, but am awarded a dispensary, you're compromising my business model. So what I'm asking again is, can I apply for a vertical license?
I think the rules and regulations will allow you to apply for the vertical license, but again, it'll be based on who submits a completed application and submits all the necessary documents and meets all the requirements for that facility. So if you submit an application for a dispensary and that's complete, you've submitted all your documents, you meet all the security requirements, there are no, your staff, yourself, the responsible official meets the letter of, the law according to these rules and regs, but somehow your cultivation site, you've got, a responsible official who has, for example, a felony conviction.
That's regardless. I mean, I'm not referring to any sort of background checking. I'm referring to
right,
vertical licensing. If I wanted to grow and dispense, one of my applications may be rejected.
That's true. Only because
one of my applications may be denied. One of my applications will not even be accepted because as the same organization, if I wanted to operate in the same village, if I have property in Dedido and I have agriculturally zoned property there, and I wanted to dispense out of the same facility to cut my costs in half so I don't have to rent another storefront, hire another set of employees. I couldn't do that because I would be applying in the same village for two separate licenses.
I think you're interpreting it wrong.
I think it's best, ma'am, if you put your question or your concern in writing, as you said you're going to do that, and that'll allow us to review it. And also, if there's necessary that we need to further clarify,
Okay.
so the language to make the language clearer, if you will,
Right.
based on your question, and we will do so. And just like I said, this is where you do have the opportunity to state your concern. Whether it's the actual content or the language, this is where we can tweak, if you will, the existing proposed language.
Well, I wanted to provide a case study to argue for vertical licensing, and so that's why I'm asking today to clarify that language. So if you can answer that question, I can provide a proper case study for it.
There's nothing still prohibiting you from doing so. As I mentioned, it's possible that the language is unclear based on the question you're asking, and we would definitely like to address that. So if you like to present as such, we're more than happy to entertain it and respond in kind later on as
Okay.
to the question. We can do that as well.
Okay, and so, but that would also be recorded as well if I,
Oh, yes.
Oh, yeah.
Everything,
Okay.
all the proceeding of the public hearing and the action that we take has always been documented. Yes, ma'am.
okay, thank you so much.
Oh, you're welcome.
Thank
ma'am.
you.
Yes. So, Mr. Wistig and Mr. Andrews, if you're interested in providing further comment.
Yeah, I just have a question. Have you addressed...
Sorry, can you come to the record for the... We do apologize, but everything's recorded, sir.
Curious, have you addressed any possible conflicts with the U.S. banking laws regarding funding, deposits, anything from the sale?
One of the parties that we did invite to our stakeholders meeting was from the banking institution, and I think it was agreed by the Department of Public Health and others, that there's certain areas within our authority that it's just simply not within our authority and within our jurisdiction, if you will, to address that. And that's something that cannot be, that is not included in our proposed rules and regulations. But it was discussed. We did have a stakeholder meeting, and there are definitely several challenges involving the finance, banking of medical marijuana. But our rules and regulations is based on our authority, the scope of the statute, and the language of the statute. So that's not included within our proposed regulations, but that matter was discussed, and it's not within our lane, if you will. It's not within our scope of developing these rules and regulations, but it was discussed.
I understand. I was just curious because U.S. banking law says that, the banks cannot accept receipts from illegal drugs. So, if you're selling licenses and everything, how's this going to reconcile with your depositing the funds in a shoebox versus a bank?
All comments submitted during this hearing will be forwarded to through all the different levels within the government for their final determination and adoption of these regulations.
Okay, thank you.
You're welcome, sir.
I'll just add on a little bit to just what he said. About a month ago, I heard President Obama said that you can now use marijuana proceeds and whatever you're dealing with for medicinal or recreational, you can deposit that in the bank already. I heard that from the President of the United States, that the bank can be used. Okay. Now,
No, that's not, I'll take issue with that. I think probably what has happened is the U.S. Attorney General has indicated that
Mr. Andrews, we have to ask that you, yes, if you need to make comments, please do on the record.
the information that I've come across and all the research that I've done is that the U.S. Attorney General and more or less have said, well, we've got other things to do, that they're not going to really uphold that end of the laws that are on the books, which in itself is a little disconcerting. Just curious as to whether or not there are any other laws that they say, well, we're just too busy to enforce.
Okay.
I think that's where you're coming from.
Okay, I'd like to add on to my earlier testimony about, patient first. Now down to cultivation. How many plants does each grower is required to plant? If I was to apply for a permit, how many plants am I allowed to grow?
Within the existing proposed rules and regulations, we did not address like a size limitation for any cultivation sites. The proposal would be given to our department along with the application for cultivation sites, and it's based on their application, how big their facility is going to be. We did not provide those specifications.
Whoever's got the most money is the winner. If I have $1 million and I'm going to build me a big warehouse and plant me 10,000 plants, then that's monopoly. That's drug lord. You cannot do that. We need to make sure that no one monopolize this thing. We need, and besides, all of a sudden everybody is a bona fide farmer. Everybody wants to grow marijuana. There were only a handful of us farmers. Now there are hundreds of farmers because they wanted to plant medicinal marijuana. If I was the senator, I would amend that rules and reg. You have to be a bona fide farmer for at least 10 years. So if you're fly-by-night farmers as yesterday, you don't qualify. You got to be farming for at least 10 years to qualify. So we can get rid of these big people that come in here. But we got to watch also, because these big people, they will go, they might want to hire me so I can apply. Now they qualify. So they can go get a 10-year farmer, bona fide farmer, and they put the name in there. Oh, he's been farming for 10 years. So we qualify. We got to watch all of these things. Make sure that nobody monopolizes this thing. It's, and I can see it already. Whoever got the most money is going to do it. Now, for our local patients here, they should be allowed to plan it. Now, if the senator can amend the law that we can allow our visitors from abroad, so long as they get permit from their doctors on their country, and then they come into our doctors over here, as long as our doctor prescribe them, then the visitors can be allowed. Now we can plan. Maybe we can make money through the visitors, but not our local people. If an individual is sick and he wanted to plan 4, 5, or 6 plans for their use, if that's what is allowed, don't make him pay a permit to plant that marijuana, because it's a sin. It's a sin to charge that sick person to plant medicine for themselves. It is bad enough, you know. It is not right to make that person sicker than what it is. I hope I'm making a lot of sense on this, and I hope you guys can have an open mind. Not just about money, not just about the operation, because the cheapest operation is to go ahead and allow the sick people to plant. I know that it have to be enforced so that the kids, but you know, if we go back and look, you go to a liquor store, everything is bad there at liquor store. People, if they, you know, they can buy that, they can drink that, and they'll get sick. And they let the little kids drink, the kids are going to get sick. So what is the difference from the medicinal? If a parent is responsible, a parent would not let their kids touch it. Everybody's keep talking. Just this gentleman is saying something about it is bad because it's like this and like that. Everything is bad. Even McDonald's, if you eat too much, you have to be responsible, parent, to do this. But let's not charge our patients permit to plan a few plans. Let them plan that thing. But I want to cultivate it for our visitors. They want to come here, okay, but give us all the chance, give the farmers a chance to grow this thing, not just a few that can put $1 million or $2 or $3 million in it and then monopolize it. No. If we got 12,000 patients, I'm going back again to our local. Some of our patients locally, they probably don't have a place to plant. It's okay. If there's 12,000 patients on the island, how many cultivators for that 12,000? Should we assign 100 patients per a cultivator? If we do something like that, then they will not monopolize it. Just 100 patients, one grower. Then you know your patient. The doctor, the patient, and the grower. Somebody's telling me, though, don't get up here and talk because you won't be making your millions. I don't care about millions. I care about the patients. I'm rich here. I can go to sleep and nothing's gonna bother me because I did the right thing. You have to do the right thing. They cannot monopolize this. We cannot charge our patient to grow this. And you have to be 10 years being a bona fide farmer to be considered to plant this, if you're going to do it commercially for our visitors. Thank you.
Thank you, Mr. Lustig. I understand we have another individual willing to testify.
Yeah, my name
For the
is
record.
Franklin Meno.
Thank you very much, sir.
I appreciate it, and thank you very much, everybody, for the opportunity. In regards to cultivating, bona fide farming, and with my hats off to Mr. Wistig, who grows the sweetest corn I've ever eaten. Growing marijuana is a different level of growing plants. One, on the patient being sick qualifies for medicinal marijuana. How are they going to pay for it if they're sick and can't hold a job, especially if a job that requires drug testing? If you're going to be a user as a patient and the company you work for screens for drug testing, then you won't have a job if you fail the drug test. Also, if the person was sick and qualified for medicinal use, $500 is a big price for an ounce of marijuana for a sick person. Who's going to pay for that if they didn't have a job? That's my question. Is the insurance people going to pick up the ticket from there? Probably not, because it's still a controlled substance in the law. So my question is, what kind of subsidies will be provided for, like welfare, for example, financial assistance? There are patients that can't barely walk, much less hold a job. How are they going to afford a $500 price tag if we start this dispensary cultivation process? There's a lot of loopholes here. There's many things that could fall apart. Some motivation is for profit. Mr. Wistig is on cue of doing the right thing. So hopefully that you guys can consider many factors. Bona fide farmer, yes, but watermelons, cucumbers, corn, that's fine. But when you open a dispensary and you're a buyer for cultivated marijuana, how are you going to control quality? What kind of testing be done on the product provided so that the patient that qualifies get the best treatment? Things of that nature. I haven't heard anybody ask about that. In regards to qualifying and working, if you fail a drug test, you're out of a job. If your company screens for drugs. So, and then children getting a hold of marijuana, that's a adult who lack the responsibility to make sure a child doesn't get the marijuana. But if a child does get marijuana somehow, they're not going to die. But if they got a hold of your bottle prescription of Percocet and ate a whole bunch of it, they'll be dead. So, as far as being worried about marijuana being dangerous, everybody needs to wake up. It's not dangerous. It's a plant. It was here. It was grown. We found out that you can feel good when you smoke it. You don't have to smoke it, so you're less likely to get lung cancer if you digest the marijuana for medical use. Things of that nature. There's too much research that proves that marijuana does help combat cancer, relieve stress, PTSD, glaucoma, and on, even eating disorders. So I can't see how something that has so much positive effect be dangerous. It was made out to be an evil drug, and it's not a drug. It's a plant. It has medicinal purposes. It's been proven, and that's why we are here today. We voted yes, and it's passed. So on the like the other gentleman was saying about the prices to have a license, I think you should lottery this opportunity instead of select. They meet all requirements for applications. Everybody throws it in, then you guys pull the names. That's to eliminate any kind of I forget the word, like okay, just push that one over there. This is my friend, for example. I mean, not to say that will happen, but in the event, it can. So to eliminate that, throw everybody's application in one box and say, okay, that will be that guy and this guy, and on and on. So I'm hoping that because your proposed rules and regulations are still in its premature state, that you guys will consider accepting applications in that matter. They have to meet all criteria, but based on a lottery, so that it keeps it fair. If I don't win it, I'm not going to lose sleep. But, you do, and also the price suggests that you have to have a considerable amount of money or really good credit to even start. Some people can grow really good marijuana and they don't even have money because it's a plant. So I'm losing track of my chain of thought really, but my point was about how are the people that are qualified for medicinal use going to pay if they don't have a job? And the doctor says, yes, you can. So the prescription from the doctor, in my view, suggests that just go to the dispensary and they just give it to you. How are they going to pay? That's the things that you guys need to work on. Because in order to afford a $500 ounce, you need to have a good job or some kind of lucrative market to make money. It's all about the money. That's what all of that stuff suggests. You need 35,000, you need another 35,000, and then 1,000, and then every year. What if Mr. Wesley says you should allow the patient to grow? You should allow them to grow. Yeah, I didn't read all of that yet, but they have to pay $35,000 to grow their own marijuana. I don't know. Excuse me, sir, but you had your chance right over here. All right. Anyway, that's pretty much my point. Is how are the patients going to qualify? I mean, besides qualifying from the doctor, how is it going to be paid if they didn't have a job? And as to the farming process, cultivation process, you should accept all applicants that meet criteria and then lottery it out to keep it fair. I don't know if that's your future plan, but I'm kind of hoping that's how that works out. I can't think of any more right now, but have a serious consideration on the patients that qualify and the amount of money you're asking per ounce. It's lucrative if you're gonna, and this was what I heard and read and stuff like that. If an ounce is worth 500 and a patient qualifies and they don't have a job because they got serious arthritic problems, how is he going to be paid for? Where's the funding for that patient going to come from? The insurance are not going to cover it. For example, that's stuff you guys should need to think about. I don't know if you could answer that.
As it was stated at the very beginning, sir, there's some there's some things beyond the scope of the act or our authority to put in the proposed rules and regulations, and I think that's part of one of the several challenges that we encountered in terms of the financing of the operation, whether it be from the standpoint of the receiver or the cultivator or the recipient, or in our case, if we were to implement the program. But also for the record, I'd like to state there's nothing in our regulations that state that the cost for the dose, if you will, I guess, for marijuana will be $500. That was just as the director said, we're not certain. I think the market will dictate that. Right. It may be 500, it may be more, it may be less. We're not certain. That was just a theoretical situation, or hypothetical situation, I'm sorry, of a possible cost. We're not certain. As I mentioned, I believe the market may dictate that. But at the moment, we have no idea how much it would cost. That will be depending upon, as I mentioned, the market.
Right. Okay, now the quality control, right, that's the most, it's like this guy can grow, it's a plant, it's got buds, but if you use it and it doesn't do anything, how are you guys going to make sure that the patient gets the best medicine?
The way the act is written, there's the department is authorized to supply an adequate supply. As far as dose, it's very difficult to determine that. I mean, whether it be Guam or even elsewhere within the nation, how do you determine adequate dose or supply? I mean, even in the smokable form of marijuana, people may take a longer, I don't know what they call it, a drag, a toke, you know, compared from one person to the other. And in terms of that amount of marijuana entering that person's body, how do you determine what's adequate? How do you control? And those are some of the difficulties that we have within our department. In terms of quality control, I mean, we identified the need to include a component for laboratory testing, because through our research, we understand that people who have autoimmunocompromised systems could be even harmed even further if they were to take a smokable form or ingested form of marijuana, medical marijuana, that is contaminated with mold, mildew, or fungus. What about pesticides? So we felt it was important that even though it wasn't addressed in the law, that we wanted, remember, we are from the Public Health Department, we're looking at it as a medical form of marijuana to treat people with debilitating medical conditions. So we included a laboratory component in our regulations.
And that would be from the grower?
That would be either at the cultivation site or at the dispensary, but definitely it will be required to have a medical component to test for mold, the presence of mold, mildew, fungus,
Right.
pesticides.
That's good. Thank you.
Thank you,
Appreciate it.
sir.
I know we do still have time. But once again, I like to say, if it's just, we ask that the speakers stick to the point of the regulations as proposed. Now, if you wish to comment on others, we're more than happy to accept so, but we request that it put in writing. I know a lot of people have comments, their personal views on this, but we want to stick truly to the purpose of the public hearing, which is for you to make your comments about the proposal. If there's any change you'd like to seek, or in addition to, we're more than happy to entertain and review your comments. Like I mentioned, you have 10 days from the last date of the hearing, which is this Friday, to submit your comments to us, and we'll review all of them. Now, if you'd like to add something new to the testimony, we're more than happy to accept those testimonies at this moment. Mr. Fest, would you like to add something new, as well as?
I would just like to re-clarify.
Sir, for the record, you need to have gone on microphone, please.
I just wanted to re-clarify something for you and you. I wasn't trying to interrupt you. And they didn't address what you asked them. You got off the subject a little bit, but it's near and dear to my heart as far as the cultivation. Caregivers. Caregivers are allowed to grow for patients, correct? Tell the people. Tell them.
There's nothing that prohibits it in these rules and regs.
There's nothing that prohibits a caregiver for growing for patients. No money involved. You as a patient, you can grow. You can be a caregiver, you can grow for people. You don't have to get in business. You can grow. No, I'm not. I think you should agree. They disagreed with me. They disagreed with me.
We're not here to argue with each other.
Well,
Mr. Fest, we respect and we honor all comments and all will be taken into consideration. Like I said, and I mentioned again, this is the opportunity to make your comments. We're not here to have an argument with any of the presentations. Like as I mentioned, if you're adding something new to the testimony, we're more than happy so.
Okay.
Adding anything new.
Want to address
And then we'll review all comments, and obviously if it needs to be revised, corrected, or clarified, we will definitely do so.
It's a little vague. You've got to search for the wording, but yeah, caregivers and patients.
Okay, we'll definitely look into that, Mr. Fest. We have your own record of your comments. Is there anything new, sir?
Something else, a different subject.
Got it.
The selection process for cultivators and dispensary people. Might be a good idea to have these people not be associated with anybody on the board or has anything to do with this program. So we get away from any kind of nepotism or favoritism. It's a suggestion.
Thank you. Thank you, Mr. Fest. Is there anything you'd like to add, sir?
Yes, sir.
Anything new, please?
In case I do, I don't know how you're going to go, lottery, or I do get chosen as one of the growers. Are you giving, am I going to be, I have to bring in the different seeds and strains from off island? Am I going to be in trouble with international drug smuggling?
Yes.
I need
The
to know
short
that
answer
because,
is yes. So the law specifically
So
states
the
that
law
there's
specifically, nobody.
no interstate.
So the grower should have his supply ready on Guam.
Correct.
All right. I guess we better start looking. Well, okay. That's the question I wanted was: are we allowed to? Because I don't think how we're gonna.
Yes, as Michelle has commented, to reiterate, by law, it is unlawful to import controlled substance into the island, including marijuana.
But are we gonna be able to let this plane pass by because it's for medicinal? You know, the seedlings or something.
Once again, sir, the law prohibits the importation of
I
controlled
just want to
substances,
make sure that
including
people
marijuana.
understood that, and you know that it is.
Okay. So with that, I believe that they received. Oh, I'm sorry. One new to add, ma'am. Something new to add to your testimony? That'll be fine. Clear. Okay. That's fine.
Okay, so it's on page 84 at the very bottom. And this language is what confused me. So if it's not your intent to deny an applicant, an individual shall not be an applicant or responsible official on more than one dispensary registration certificate and/or cultivation site registration certificate application. The problem with this language is the and/or. And so I guess that's why I was here, was to clarify that it wasn't your intent to deny the and. If I wanted to apply for a dispensary registration certificate and a cultivation site registration certificate, I would not be denied.
I think the issue with that section is the CHA, because the CHAs were separated into 3 areas: northern, central, and southern. So I think the main point in that area is that it's for a location in a single CHA. So you can't have a dispensary. You can have a dispensary and a cultivation site in one CHA.
Okay, but the language is open to interpretation, right? It's loose.
Right.
So
If that's the
if
case-
that's not your intent, that's what I'm trying to clarify.
Well, that definitely will look into that, and if it really requires clarification, it will do so. And by the way, I'd like to mention that the draft final product will be forwarded to the Office of Attorney General for their legal review.
Okay.
So they have opportunity also to comment if there's requires any clarification, especially from a legal perspective.
Okay, I just want to make sure that when I submit an application, if I submit for more than one, that my application is protected by the language in these rules. So thank you. If you could just, I guess, advise on that.
Yeah, Mr. Fest, is there something new to add, sir? Okay, so.
I don't mean to irritate you.
Oh, no, not at all. We want to make sure that we get everyone absolutely correct, so we're giving everyone the opportunity. We want to make sure that we're not repeating the same thing over, because we do have.
No, this is
Please, sir,
Really
then,
should-
please.
suggestion. Expand the conditions that the doctor can advise their patients that it might be helpful. Expand, big time expand. Like you've got the arthritis limited to autoimmune and rheumatoid. There's 108 different flavors of arthritis, and you're limiting to one.
Your comments will be definitely considered.
And, you know, different depression. We've got getting persons off of hard drugs and alcohol, harm reduction, what it's called. Many things. Many things. You've got this way too limited to really benefit the maximum amount of patients.
Just to comment on Mr. Fest's comments, the list of debilitating medical conditions was defined and specified by the law. So with these rules and regs, we had no choice but to limit it to the law. There is a process for petitioning process through the advisory board for the director to consider adding additional debilitating medical conditions. So those are specified in the rules and regulations. A petition process through the advisory board, correct.
And with that, I believe that will. Yes, we have the honor of our director, Mr. James Gillen.
I wasn't going to, but I have to. Especially Mr. Wistik, thank you very much for your comments. And Mr. Fest, thank you also. You're right about some of the questions. Not clear, and that's why we're having the hearings, to make sure we're very clear about what we're doing here, because this really is an important matter. But when we talk about cost, okay, we talk about the charge per ounce. If I had a choice, we'd get it as low as possible. But I think we're going to have a problem here because the law says that we have to regulate and we have to oversee, and we have to have a database, we have to have a whole lot of things that cost money. Now, if we can get it down to where the cost of the government overseeing this program is fairly minimal, and I think that's what we're doing at least with the certification process, that should have some impact on what the cost is going to be for the patients who need access to this medication. But I will say to you that medical marijuana isn't always the issue. I just looked at something the other day. There's the cost for one tablet for the treatment of hepatitis C. One tablet, folks, is $1,300. So, and there, okay, the people who cannot afford the medication who are on some of our programs, that gets passed on to us. We do want to keep the cost of the medical marijuana down, but we will not be able to control that market. We talk about monopoly. We prefer not to have a monopoly because there's always that opportunity to control the cost in the market. You get the price down too low, and let's get real, folks. Marijuana is available in the community, and it's available for a price. If our prices are below those, all right, we compete with the street. And when you compete with the street, you have a lot of people now wanting to be on the medical marijuana rolls. That's what's happened in Colorado with the recreational marijuana, where because of the taxes, the recreational marijuana is more expensive than the medical marijuana, so people are breaking down doctors' doors to get included on the medical marijuana rolls. We don't know how to deal with this problem. We really don't. We think maybe some market forces will take care of some of the costs, but it's not going to be cheap. And you're right, Ernie. What about, the patients who don't work, who can't work because of their condition? How do they get access to it? Well, we know the insurers can't cover it because of the federal laws. We know that Medicaid won't be able to cover it because of the federal laws. So we have that situation. It's almost a no-win. And I don't think the legislature has the wherewithal to say, okay, we're going to pay for whoever can afford to pay for it. When we did that little exercise on the board, it was like $9 million based upon 3,000 patients at $500 an ounce. And that wasn't to show anything other than that's the kind of money that we're talking about here, and that kind of money attracts a lot of interest. I'm not interested in making anything other than what it costs the government to operate this program. I mean, selfishly, I'd love to have, $80 million and have that tax so that we put it into public health and education programs, we can put it into public safety to help us regulate the programs. But, let's be realistic. We have to be able to provide this at a cost where the government, the cost is low, and hopefully that the cost to the patient is low. But those questions are not really the concern, unfortunately, of this legislation. We don't drive the market. We don't control the cost. But I appreciate all the comments because they're all very valid. And it helps us, as Tom said, tweak this a little bit. But there are some things that are beyond us. We can't tell the Employers Council who to hire, who not to hire, who to screen, not to screen. We're going to have a lot of lawsuits, okay? And we look at the list that's on the Arizona experience. They're being sued over all kinds of things, even the lottery they're being sued over. So we see that this is not going to be a simple thing to get done, but the legislature has seen fit to have the people vote on this. The people have said they think it's a good thing to have, so we're going to do what the law says we need to do. Thank you.
Thank you, Director. So with that, unless there's one final comment from someone new to add something new to the hearing, their comments, we will close the public hearing. So tomorrow? Yes, so we are having our second public hearing tomorrow, 9 to 11, same venue. Yes, and they're welcome to come back tomorrow to add their comments, new comments. Well, as I mentioned, we're more than happy to accept written comments as well. If you do not wish to provide oral testimonies, we'll accept written testimony equally. We have 10 days after the Friday hearing, which will be held at Castle Mall in Manila. Yes, and of course, it doesn't have to be, we'll accept anonymous testimony, written testimony as well. Also with that, thank you everyone for the comments. And once again, we do take all comments seriously, and we will definitely review all of them. Thank you very much. Thank you. So it is now 10:28, and we are now closing the public hearing.